All right, future barristers, let's jump right in. Today, we are sharpening one of the most critical tools in your entire advocacy toolkit. It's the power to get evidence thrown out, evidence that, on paper, is perfectly admissible, but in reality is just fundamentally unfair or was obtained improperly. We're talking, of course, about Section 130 of the Queensland Evidence Act.
So, picture this. You're in court. The Crown gets up and presents a piece of evidence. All the technical boxes are ticked. It seems fine, but your gut is just screaming that if the jury sees this, it will completely poison the well, that it would destroy any shot your client has at a fair trial. Now, this isn't some abstract hypothetical. You will face this moment. So what do? Well, the answer lies in something called judicial discretion.
And to get you ready for that moment, here's our game plan. First, we're going to unpack the gateway itself, Section 130. Then, we'll dive into the two huge common law powers it unlocks, the Christie discretion for fairness and the Ireland discretion for public policy. Then, we'll see how they actually work in practice, and I'll leave you with a final thought that is crucial for your career. Okay, let's get into it. First up, we need to look at the legislative anchor for everything else we're going to talk about. Now, I want you to think of Section 130 not as a detailed rulebook, but as this small, almost hidden gateway that opens up a massive field of common law power.
Look at the wording here. It's incredibly brief, almost cryptic. And notice what it does and what it doesn't do. It doesn't create a new power. It says nothing in this act derogates from, which is legal speak for it preserves a power that already exists. This one little sentence confirms that judges in Queensland can reach back into a deep well of common law precedent to throw out evidence and make sure a trial is fair.
So when we say discretion, what do we really mean? It's not about a judge just doing whatever they feel like. In this legal world, it's a very specific power to override the normal black and white rules of admissibility. It lets a judge step in and make a nuanced judgment call when just blindly following the rules would lead to a completely unjust result.
You know, the law wasn't always this flexible. Way back in 1790, the view was super rigid, no discretion allowed. But the realities of the courtroom forced a change. This led to the birth of the Christie discretion in 1914. It eventually made its way to Australia, and then in 1970, it was joined by the powerful Ireland discretion. And what's really key here is that even our modern laws, like the PPRA, are written specifically to keep these fundamental common law powers alive and well.
Okay, let's move on to the first major tool in the toolkit. This is the Christie discretion, and I want you to think of it like a surgeon's scalpel. It is used with incredible precision to cut out a very specific type of evidence, the kind that is unfairly prejudicial to the person you're representing.
Right, this is the definition you need burned into your memory for the bar exam. The absolute heart of the Christie discretion is a balancing act. Imagine a set of scales. On one side, you've got the evidence's probative value. That is, how much does it actually help prove a fact that's in dispute? And on the other side, you've got its prejudicial effect, which is its tendency to make the jury decide the case based on something improper, usually an emotional reaction.
This is a massive distinction, and you have to get it right. Look, pretty much all Crown evidence is prejudicial, in the everyday sense. It's meant to damage the defense case. But that's not what we're talking about here. The legal meaning of prejudicial effect is about damage to the fairness of the trial itself. It's the risk that the jury will misuse the evidence and be led completely astray from their real job.
And please, don't think of this as a simple 50-50 balancing act. It's not. The scales have to be tipped heavily in one direction. Your job, as the advocate, is to convince the judge that the evidence has very little real proof to it, while its power to create unfair prejudice is just huge. Only when that gap is massive will a judge step in and exclude it. So this is where the rubber really hits the road. These are the classic situations where you'd stand up and make a Christie application. Unsigned police records of interview? Prime example. Gruesome photos that might just horrify a jury without adding any new information? Absolutely. Weak eyewitness ID, evidence from hypnotized or unstable witnesses, all of these carry a huge risk that the jury will give them way more weight than they rationally deserve.
Now for the second tool in our kit, the Ireland discretion. Look, if Christie is a scalpel to protect the accused person, I want you to think of Ireland as a shield. It's used to protect the integrity and the reputation of the justice system as a whole.
See how the focus shifts here? It's a dramatic change. We're not just worried about fairness to this one person in the dock anymore. The Ireland discretion asks a much bigger question. Was this evidence obtained because the authorities did something illegal or improper? And if it was, should the court, as a matter of public policy, refuse to give its stamp of approval to that conduct by allowing the evidence in?
This slide really says it all. You've got the two discretions side by side. One protects the player, the other protects the game. Knowing which one applies in your situation and why is absolutely fundamental.
Now, while the Ireland case set up the principle, the way we actually apply today comes from another huge high court case, Bunning v. Cross. This case is so important that you'll often hear lawyers talk about the Ireland and Bunning v. Cross discretion. It's the case that gave us the practical how-to guide for judges making this big public policy decision.
So how does a judge actually do this? Well, they perform this really sophisticated balancing act, and they ask a few key questions. First, what's more important in this specific case? Convicting this offender or protecting all of us from official misconduct? Then, was the illegality a genuine mistake, or was it a deliberate, we don't care about the rules kind of breach? Does the misconduct actually taint the reliability of the evidence itself? And finally, you have to compare the seriousness of the crime the person's accused of with the seriousness of the police misconduct. Right, that's enough theory. Let's look at how these discretions are actually argued and applied in some real-world courtroom scenarios. This is the stuff you really need to be ready for.
Okay, like we said, an unsigned record of interview is a massive red flag. Its probative value is pretty weak. It's just an officer's word against your clients. But the prejudicial risk, it's huge. The judicial thinking here is simple and pretty cynical. If an officer's willing to lie in the witness box, they're probably more than willing to create a false document to back it up. That's a risk of prejudice that is often just too great for a jury to properly handle.
Graphic photos are another classic Christie problem. The question you always have to ask is, what does this photo prove that we don't already know from other evidence? In one case, where the accused had already admitted the attack was ferocious, the horrible photos were excluded because they were seen as purely inflammatory. But in another case, photos showing the victim had been trussed up were admitted because they were highly probative. They help prove that more than one person had to be involved. It all comes down to context.
And this scenario is pure Ireland and Bunning v. Cross territory. When evidence is found during an unlawful search, the argument isn't about prejudice. It's all about the police misconduct. In the case of RVN, for example, police seized a mobile phone without any lawful authority to do so. The court, applying that public policy discretion, excluded not just the phone, but all the data on it, sending this really clear message that the ends do not justify illegal means.
So, we've unpacked the law, we've looked at the cases, but the final and honestly the most important piece of this whole puzzle is you. These discretions aren't self-executing. They don't just happen. They exist because skilled advocates like you will know when and how to stand up and argue for them.
So, let's just boil it all down one last time. Christie protects the accused from unfair prejudice. Ireland protects the entire justice system from official misconduct. One is your scalpel for fairness, the other is the shield for public policy. Internalize this distinction. This is the absolute core of your toolkit.
And this really is the philosophy that underpins everything we've just talked about. The rules of evidence are crucial, of course, but they are always in service of a much higher goal, and that is justice. These discretionary powers are the system's ultimate safety valve, making sure that a technical rule can never be allowed to create a fundamental injustice.
And that leaves us with the ultimate question, one you will grapple with for your entire career. The Evidence Act provides the rules, but advocacy, that provides the judgment. Knowing where to draw that line between a technical win and a just outcome, that is the true art of being a barrister. Something to think about.